Impeachment. Impeachment approach and overview. Impeachment casts an adverse reflection on the veracity of witnesses' testimony. Any party may impeach any witness. Methods of impeachment. Contradiction, prior inconsistent statement, bias or interest, sensory deficiencies, such as when a witness' senses were incapable of producing the perception to which a witness testified, reputation and or opinion of untruthfulness. This is admissible to impeach witnesses' veracity by use of extrinsic evidence. Prior acts of misconduct, such as extrinsic evidence is prohibited, and a prior criminal conviction. Evidence supporting witness credibility is inadmissible unless credibility has been attacked, such as witness has been impeached. Exception is when witness's prior consistent statement is admissible if the statement was made before the witness had a motive to fabricate. Extrinsic evidence may be used to impeach a witness except on collateral matters. Extrinsic evidence is any evidence other than the witness's testimony at the current proceeding. This includes evidence of out-of-court prior inconsistent statements. Extrinsic evidence of contradictory facts is admissible to impeach witness on material non-collateral matters. Collateral matter is a fact not material to issues in the case. It says nothing about witness's credibility, only used to contradict witness. So for example, witness 1 testifies he was headed to the store when he saw a defendant commit murder. Defense cannot call witness 2 to testify that witness 1 was really headed to see his mistress. This is collateral, not material to the issue of what witness 1 saw. The test to determine if evidence is collateral asks, would the evidence be material to the given issue if not for witness's contradictory assertion? If not, it is likely collateral. Contradiction. Any evidence may be used to show witness has made contradictory statements on material issues. Prior inconsistent statement. Witnesses' prior inconsistent statements may be used to impeach witnesses' present testimony. Establishing a prior inconsistent statement, it may be established through cross-exam or extrinsic evidence. Extrinsic evidence is inadmissible if the prior inconsistent statement relates to collateral matter. Foundation requirement. Witness must have an opportunity to explain or deny the statement. Not required for prior inconsistent statements by a hearsay declarant. Prior inconsistent statements and hearsay. If prior inconsistent statement is hearsay, it is admissible for impeachment purposes, but inadmissible as substantive evidence to prove the truth of the matter asserted. Hearsay prior inconsistent statement may only be considered for its bearing on the witness's credibility. If the prior inconsistent statement is not hearsay or it falls under a hearsay exemption or exception, it may be considered for any purpose. Evidence of witness's bias, prior misconduct, or reputation for untruthfulness may be used to impeach the witness. Impeachment through establishing bias may be established through cross-exam or extrinsic evidence. Foundation requirement. Witness must be questioned on cross-exam regarding the facts that show bias or interest so that witness has an opportunity to explain or deny. Impeachment of prior instances of misconduct. Witness may be questioned on cross-examination about any prior misconduct probative of truthfulness, such as lying or deceit. Arrest is not misconduct, must be an act of lying. No extrinsic evidence is permitted. Witness may only be asked about prior misconduct. Questioning attorney must accept witness's answer. Impeachment based on opinion or reputation for untruthfulness. Witness may be impeached by testimony describing his reputation for untruthfulness in the community. Admissibility of impeachment by type of prior conviction. So, with prior convictions or felonies not involving a dishonest or false statement, if witness is the defendant, it is admissible if government shows probative value outweighs the prejudicial effect. If witness is a non-defendant, it is admissible, but the court can exclude it under 403 balancing. Misdemeanors are inadmissible unless it involves dishonesty or a false statement. This is distinguished from prior conviction involving an act of dishonesty. Those are always admissible. Court has no discretion to exclude under 403. There's a rare exception to 403. It includes felonies and misdemeanors. Acts of dishonesty, prior convictions required proof or admission of an act of dishonesty or false statement, such as perjury or fraud, which is also distinguished from convictions more than 10 years old or felonies and misdemeanors. This is not admissible unless probative value substantially outweighs the unfair prejudice. Note, this is like an inverse of the 403 balancing test. An adverse party is given notice. Determining the tenure date, more than 10 years must have elapsed since the date of conviction or the date of release from confinement, whichever one is later.